Welcome, everyone. This is Susan Milazzo with the California Mortgage Bankers Association, and welcome to our first Mortgage Quality and Compliance webinar for 2020. We will be featuring today's webinar as kind of a dual purpose. We also are kicking off our first CCPA quarterly webinar, which is today's topic of our MQAC webinar. So kind of two birds with one stone here, and I want to thank our presenters for being a part of it. Just to kind of welcome everybody and give you a few remarks about this webinar, if you haven't been a part of this in the past, we offer these on a monthly basis. We feature a different compliance issue that's something that's kind of a hot topic in the industry, and provide some great content. We record all of these webinars, so they'll be made available to you to use in the future, or maybe to use as a training tool for somebody in your office if you so desire. I would like to introduce Carol Carson, who is with Plaza Home Mortgage, and she is our committee chair. Carol, would you like to have any welcoming remarks to the group?
Yes, thank you, Susan. Good morning, everyone. I'm Carol Carson. I'm the Chief Compliance Officer at Plaza Home Mortgage. This year, I'll be serving as the chairman of the CMBA's Mortgage Quality and Compliance Committee, along with my illustrious co-chair, Ray Snytsheuvel, founding attorney and of counsel at Garris Horn, and Chief Operating Officer of Firstline Compliance. It's our pleasure to welcome you to another fantastic year of insightful and timely webinars hosted by MQAC, and we're going to start off this year with a bang. So thank you, Susan.
Yeah, great, and thank you so much for your leadership this year. Each of our webinars, we cover a little bit of a legislative update, what's happening in the state of California. We also invite and that's provided by our lobbyist, Pat Zenzela. We also have a legal update, talk about some sort of a specific litigation issue, and that is covered by our general counsel, Michael Pfeiffer, before we get into our presentation. So with that, I'll go ahead and get us started. We've got a lot of information to cover today. So Pat, welcome Pat Zenzela to the webinar, and he's going to share with us a little bit about what's happening in Sacramento, in our state capital, within the legislature. Pat, I'll turn it over to you.
Thank you, Susan. Welcome, everybody. And just to give you a sense for where we're at in the legislative session, the legislature just started their second year of the two-year session on January 6th. And we haven't seen a lot of bills introduced this year. So it's starting off a little slow as far as bill introductions. We'll see basically just over 2,500 bills introduced by February 21st. So things are going to pick up very quickly and very soon. But it hasn't been a boring time in the Capitol. We've already had a significant proposal being put forward by the governor. Basically, the governor put forward his new budget proposal for 2020 to 2021. And as part of that proposal, he is announcing his desire to reorganize the Department of Business Oversight into what's going to be called the Department of Financial Protection and Innovation. That plan proposal, he says, is necessary because California doesn't have one single entity, so in other words, just one regulator that oversees the state's providers of financial products and services. So he believes that leaves the consumer vulnerable to abusive financial products and practices. So the DBO restructuring will help to essentially protect consumers in that regard. They also make it clear in the plan that it's modeled on the Federal Consumer Financial Protection Bureau. So what this means is that the jurisdiction of if it moves forward as it's planned out, the jurisdiction and authority of the DBO is going to be significantly expanded so that it can bring actions against unfair, deceptive, abusive practices and financial providers. And specifically, it would grant the authority for the DBO to go after financial service providers licensed or registered with other agencies, and they specifically reference the Department of Real Estate, the Bureau of Real Estate Appraisers, Department of Insurance, and the Department of Justice, but it can go beyond that, at least based on the initial plan. There's even a question as to whether there'll be efforts to go after federally chartered entities. So what are the details? We don't have a lot of details yet. We'll likely get that information by the first week of February, but what we do know is that the reorganization is going to include a new financial technology innovation office in San Francisco. They say this is to encourage innovative financial products and services, but we also know that a big part of what this proposal would do is focus on fintech and unlicensed online lending, which the DBO has been grappling with for several years now. It's going to create a new consumer financial protection division that they say is focused on research, education, outreach. It's going to create a new supervision and registration office, and I think this is a key part of the plan because they're predicting that they're going to bring in 9,000 additional registrants who are offering financial products who currently are not licensed by the DBO. So clearly that's going to be a focus of the new DBO. They're going to significantly grow their enforcement division, and then they're also going to have a new Office of Communications to publicize the DBO's expanded enforcement efforts, et cetera. So a lot of new departments and offices and divisions within the DBO. What does that mean as far as costs? They're predicting that it's going to cost about $44.3 million over a 3-year time frame, and they're going to need 206 new positions in order to get this restructuring to move forward. They're saying that the initial funding, the $44.3 million, is going to come from settlements that they've had with current licensees. So they're going to take those funds that are the DBO already has and use it to fund this. But after the 3-year period, they say that they're going to get the funding they're going to need from the 9,000 new registrants and also from existing licensees as far as additional fees and assessments. So stay tuned. When we have more details, we'll get that information out. The other thing I just want to mention very briefly is with respect to the CCPA, which we're going to hear a lot more about later in this call. The Attorney General has released a draft of the language, and we have made comments on that most recent draft, and we're waiting for feedback from the Attorney General as far as any changes to that draft. Hopefully that will be made available at the latest by late March, early April. And then we expect there to be a short commentary time frame, like 15 days, and we don't expect to see many changes past that, and it's designed to go into effect on July 1st. So there's still a lot of activity on the CCPA regulations. And with that, I'll move to the next speaker. Thank you, Susan.
Okay, great. Thank you, Pat. Yeah, very early in our session, lots to be looking forward to this year. We've got already a pretty busy agenda. So next, I'd like to invite Michael Pfeiffer to run through our presentation, our legal update, and talking about this AAPC case. So Michael, I'll turn it over to you.
Thank you, Susan. You go ahead and control the slides for me, please. This case is called the American Association of Political Consultants versus the FCC, and it's an appeal. It's on appeal to the U.S. Supreme Court. The Supreme Court has accepted this case for review, and the reason that I've included it is not only does it deal with privacy, which is the topic of our webinar today, but it involves a significant piece of legislation that the industry has been dealing with for several years now, called the TCPA, Telephone Consumer Protection Act, and which is a form of privacy statute. And as many of you know, there's been a tremendous amount of litigation in this area. It has been going on for several years. Courts all over the country have construed it in different ways. But this particular case, so this is the first time that the thing has gone up to the Supreme Court. I think I think I'm correct on that. And goes to the constitutionality of the whole statute. Obviously, if the statute is thrown out, that will have a tremendous impact on the industry. So the issue presented to the Supreme Court level, however, is whether a certain exception, the government debt exception to the TCPA restriction, violates the First Amendment. And if it does, whether the proper remedy for this violation is to sever the exception from the remainder of the statute or declare the entire statute unconstitutional. The review was granted on January 10th. Next slide. This gives you a little bit of background of the Act. It was passed in 1991, and as many of you know, prohibits the use of automatic telephone dialing system or an artificial pre-recorded voice or pre-recorded voice to make any call to any telephone number assigned to a cellular telephone service. And it accepts from that automated restriction any call made for emergency purposes or with the prior express consent of the called party. In 2015, there was an amendment to the Act in which Congress also added an additional exemption for calls made solely to collect a debt owed to or guaranteed by the United States. Next slide. In this particular instance, the respondents, the political consultant group, wanted to use the telephone dialing system or an artificial pre-recorded voice to make calls to cell phones for potential registered voters to solicit political donations and advise on political and governmental issues. Many of you have received those calls, I'm sure. That's been going on for the last couple of years. The Fourth Circuit held, however, that the government debt exception to the CPA's automated call restriction violates the First Amendment, basically because it is a content-based discrimination, essentially, and is a direct and most severe form of violating of the First Amendment. The court further held that the proper remedy was to sever the government debt exemption, leaving the basic automated call restriction in place. And so the FCC and the U.S. Attorney General William Barr petitioned the U.S. Supreme Court for review. It was granted on January 10th. Next slide. And so these are the arguments. And basically, Attorney General William Barr is arguing that on behalf of the government, that holding the government debt exemption violated the Constitution is itself an error, and the court's application of what's called a strict scrutiny standard was unwarranted. And basically, they're saying under the appropriate level of scrutiny, the government debt exception is constitutional. I personally believe that argument is weak. Having read the Court of Appeal decision, their analysis is pretty cogent. The government tried to argue that the First Amendment exception, or the First Amendment wasn't violated, and it wasn't a content-based restriction. But when you look at the whole purpose of it, that's clearly what it is. It deals with debt collection calls and nothing else. So basically, in laying forth their arguments, Attorney General Barr basically said the question presented in this petition encompasses the subsidiary question of whether the appropriate remedy is to sever the debt exception rather than to invalidate the entire TCPA. The American Association of Political Consultants had asked for the entire statute to be invalidated. Next slide. So the Supreme Court basically has three choices. They can declare the whole thing unconstitutional. They can declare that the debt exemption is unconstitutional but sever it, or they can declare the entire TCPA unconstitutional. And as I've indicated, basically at fate are hundreds of currently pending lawsuits. And also there are, and even more importantly, there's some high-profile law firms that have built huge practices out of specializing in this. I mean, there's even one that has a website TCPA world where they analyze all of these cases, and you can go there and you can see how prolific this litigation has become. So not only are members of our industry affected, but the lives, fortunes, and careers of many attorneys are impacted by the outcome of this. So I personally think that the court will hold the exception unconstitutional and sever it, but that's just my personal opinion. It's certainly to be watched. This is the first time that the entire onerous TCPA statute, onerous is not necessarily everyone's view of it, but it is a big problem, is going to be before the Supreme Court. So watch it. Let's see what happens, and that's my report for today.
Great. Okay. Well, thank you very much, Michael. Appreciate that valuable information. And now we will move into our presentation for this month. And Carol, would you like to introduce our speakers? Carol, are you there? Possibly we have lost Carol's connectivity. I apologize for that. So with that, Raymond, if you are okay to start, I'll go ahead and introduce you. We have Raymond Snytsheuvel, who is with Garris Horn and Firstline Compliance, as one of our presenters today, and Sandy Shatz with McGlinchey Stafford, who's of Counsel with the firm, and they put together today's presentation on our CCPA workshop. So I'll go ahead and turn it over to you, Raymond.
Okay, thank you very much. Let me see. Hold on for a minute and make sure I have my connectivity. Thank you for that. Thank you, California Mortgage Bankers Association, for the opportunity again to speak, particularly on CCPA, which is fun. So what we did today, and I know we've spoken, and people probably heard me spoken, other people speak before, in regards to CCPA, what does it mean? We did this in the last, 2 quarters of last year to prepare for it. And so I thought we'd kind of move along and see, what do we do now? So it went live on January 1st. We start to see the real issues bubble up. I have, clients and friends who are contacting me, what do we do in this case? And things we probably hadn't thought about. And I think it was because, we knew the devils were in the details. We just didn't think the devil was going to be this devious. And you start to figure out that, in fact, there are things that, we hadn't thought about that. Would we look at it differently? And find out really, with the lack of clarity in the law and the lack of regulation altogether, it's hard for us to really establish what the standard should be. So what do? A lot of the compliance folks know this. We call our friends and create our own standards because it's all gap filling is what we're doing. So that's kind of where we are with it, and I thought we would try to touch on that. I know Sandy will go. Will take most of control of the presentation, and we'll talk a little bit of where it came from, but not too much of that. Mostly, again, some key issues that Sandy sees, and then see how we can apply it into real world practicality. So, with that, Sandy, if you could go ahead and take it from there.
Hello, everybody. This is Sandy Shatz from McGlinchey Stafford, and thank you very much for joining us. And I would like to thank Ray and Susan and the CMBA for inviting me to come in. On page 2, we have our plan for the next 30 or so minutes. We're going to talk about the CCPA and really focus on discussion topics, issues that have arisen, things where you just want to say, Let's go to the next page, Ray. With the enactment of the CCPA, I want to share with you that this is a gigantic shift in how we think about privacy. Up through the various enormous data breaches by our credit agencies and others, people thought of privacy and data security as, I have data, I have to secure it and pray there's no breach, and if there's a breach, I have to deal with it and pay a lot of money. With the CCPA, the GDPR, the shift is focusing completely to who owns the data, who controls the data, and who uses the data. Data breaches are still a part of this, but they're a very small part of this. The real focus is on understanding of privacy and data is data control and data relationships. If you think of implementing the CCPA that way, it will help guide your policy decisions and your decisions. While data breach is out there, Section 150, and it poses liability, and we'll talk about it, the issues are, no, I'm the consumer. This is my data, and you can't use it except for purposes for which I give you permission. The industry, our industry, can look back and say, well, that's cool, but we have the GLBA exemption. No. I'm going to argue we really don't and share with you why it's, one, we don't have it, and two, why it's not such a big issue. And we'll talk about what you can do about it. And while it's there, please don't adopt the provision, the view that there is nothing I need to do because it's GLBA exempt. Go on to the next slide. You're familiar with the summary of law and new rights. We're assuming this is not the 101 course, but the 201 course. I've put this in just to make sure everyone's up to speed. While the statute identifies 6 rights, sections 100 through 135, there are really 4 groupings of rights. A consumer has a right to know, a right to delete, a right to opt out, and a right for non-discrimination. We'll come back to that. We, the industry, have to provide certain disclosures and update our privacy policies. The big issues for us will come down to verifiable consumer request and compliance with that request. And enforcement is not really a huge issue, it's just there. That's our summary of the law. Go on to the next slide for definitions. I want to touch briefly on these definitions and ask questions. The definition of business is the starting point. As anytime you engage in statutory or regulatory interpretation, you need to know what you're talking about. The definition of business, if you are enormous, okay, you're covered, you're a business. If you are small, you're not covered, you're not a business. The issue arises if you're somewhere in between, and there are 2 paragraphs in the business definition. The definition of business in paragraph 1 is, I'm going to paraphrase, some type of legal entity, such as a proprietorship, partnership, limited liability company, corporation, etc., that either earns money or wants to earn money and collects a consumer's personal information. Put that portion in your brain, and then there are 3 thresholds. $25 million in revenue, $50,000 in persons or devices, deriving 50% or more of your annual revenue from selling a consumer's personal information. The definition of business does not include your affiliates, your subsidiaries, and your controlling or controlled entities. It's just, does the business meet these thresholds? So if your holding company, the main holding company, doesn't collect consumer data, it's not a business. If your main holding company doesn't generate sufficient revenue, it's not a business. And if your operating subsidiaries individually don't meet that definition, then they come under Section 2. Any entity that controls or is controlled by a business as defined in paragraph 1 that shares common branding, etc., is part of the business, but you first have to have a business. I kick this out because if you are of that size and have prepared to comply with the Act, it may not yet be applicable to you. Second definition is business purpose. Okay, a business purpose means you use personal information to do your business. Perfect. Commercial purpose means you want to advance a person's commercial or economic interests by inducing further commerce. The purpose of these, the reason for mentioning these, is when you disclose to a consumer the purpose for collecting, using, storing, sharing the data, you can go only this big. You don't need to go granular. You don't need to say we're asking for your income because we'll underwrite it this way. It's okay to say we're asking for your income for a business purpose. Fourth topic, consumer. Definition of consumer is key. Okay, we know who California consumers are. The operational trick is figuring out Is my customer a California consumer? Some of our out-of-state entities, various credit unions with national reach, etc., have said, for purposes of this act, it's too hard to decide, so everyone is a consumer. If everyone on this phone is a California-based business, then you can assume most of your people are, in fact, consumers. But if much of your work is out of state and you don't have a lot of California consumers as customers, you have to figure out how you want to handle it. And yes, it's easy to make everyone a consumer, but that will involve certain costs and risks to you. Fifth definition to look at is personal information. This one is easy. It's, in layman's terms, anything you can think of about a person. That's just the easiest way to look at. Everything you got is personal information. Last two definitions, service provider and third party. A service provider comes up as any type of corporate entity, sole proprietorship, partnership, limited liability company, that's in it to make profit and that helps you. That helps you do your business and works for a business purpose using the consumer's personal information. That's a service provider. Your last choice is either business service provider or third party. And a third party for operational purposes is someone who's not a service provider and not a business. They're a third party. Those are the big definitions, the key definitions. So with those definitions in mind, let's turn to the Act. But before we do, next slide please, Ray, let's talk about, does the Act apply to me? Here is the text of the GLBA. You went one too far. GLBA exemption. Go back one, please. Going the wrong way. It's slide 6. So well, I never read slides, but now I'm going to. This title shall not apply to personal information, back one more, collected, processed, sold, or disclosed pursuant to the Gramm-Leach-Bliley Act and implementing regulations, or the California Financial Information Privacy Act. That's what it says. And that's what I'm told many financial services companies are hanging their hat on, that we do not need to comply with the Act. And I want to suggest to you that's not true. And then tell you how to deal with it. First of all, the plain language says, this title shall not apply to personal information collected pursuant to GLBA, or processed pursuant to GLBA, or sold pursuant to GLBA, or disclosed pursuant to GLBA. Ask yourself, under the Gramm-Leach-Bliley Act, what information am I collecting? Or what information am I processing, selling, or disclosing? And the answer is none, because the Act doesn't require it. This is inartful drafting. Yes, the statute likely meant to apply to our business and should be exempting us, but I don't think it did that. And when you look at the purposes of the Act being who controls the data, who owns the data, how can we protect Californians whose data is being abused, the GLBA exemption likely will be read narrowly. As another indicia of that, when you look at how medical information is treated, the language is very different. It's more broadly construing. Medical information in large part is exempt. And if you look at the bill currently pending in the Assembly, AB 713, it broadens it even more in the medical arena and doesn't touch financial services. Finally, even Alistair McTaggart, the chap who put the proposition on the ballot and began this, as part of his most recent proposition that likely will be on the November ballot, he rewords this exemption to be, under Gramm-Leach-Bliley, personal information collected, processed, sold, or disclosed, subject to the federal GLBA, etc. So if you don't like the new proposition, as a way of at least making you feel better, the GLBA exemption will become much better and usable. Not to worry, because of financial services requirements and regulations, There are so many other exemptions we can draw on. The failure of the GLBA exemption shouldn't cause us any worry. Let's go to the next slide. Overview time. I just wanted to talk about disclosures.
Okay, hold on. Let me see. I'm working on it. I have a delay on this thing. I apologize.
Okay, no problem.
Then it goes too
Disclosures.
fast.
So remember that there's a variety of disclosures that are required under the Act. Disclosures before the collection of information, disclosures of a right to opt out, notice of financial incentive, right to delete, or a privacy policy. How and when do you deliver those disclosures, and in what form should they take? We'll come to that when we get to implementation issues, but put those in your mind. There is a commonality. When you read the proposed regulations as to what the disclosures are supposed to look like and be like, those disclosures are, I just got the email saying the webinar ended. Are we still there?
I am still here.
Okay. No, we're still here.
So the notice is, okay, good, because good.
The
disclosures
Susan,
are...
Real quick, if I may, real quick, sorry, technical issue. I can't switch the slides.
Okay, I will take that over. And then
Thank
Sandy,
you.
I apologize, everyone. Sandy, I think we need to go to 8, okay? Mm-hmm.
There you go. So all of the disclosures, according to the proposed regulations, we have no reason to believe they'll change. The regulations have to be easy to read and understandable to an average consumer. Think of Forrest Gump as the average consumer. As you all know, when you originate a loan, all of your customers are extremely knowledgeable. They don't want to hear about the stuff. They just want to know how much can they get and what's the monthly cost going to be. And yeah, they know, yeah, they know, yeah, they know. Until the loan goes into default and you take their deposition and you get, they didn't tell me, I didn't know that, I didn't understand that. That's all in legalese. I had no idea. Your notices are the Forrest Gump level, please. Plain and straightforward language.
Sandy, and if I can add to that, we talked about this, and I think everyone understands it as well. As we pass the January 1, I think a lot of us are looking at other people's notices. And there are a lot of different iterations of notices, and for me, I can imagine, especially if I was in-house, I would take pause and second and third and fourth guess as to whether my version is the correct one, right? Or did I miss anything? And I think what ends up happening is, I think of all these iterations, and I think, Sandy, you mentioned there's about 100 of them that you're collecting so far. Of all these iterations, yeah, there you go. You get the 100. So I think they're all compliant. I mean, we don't really know. I haven't checked all of them. Maybe something missing. But in the grand scheme of things, I think they're compliant. I think the issue here is, as I say, it's kind of like ice skating, right? It's a matter of scoring your ice skating score. You have technical points and you have style points. And I think the focus is ensuring that you are at least hitting the technical points that in the law says you must disclose this, category or piece of information, et cetera. And you've done your best to define it and outline it, especially as applicable to your business. Just because it looks different doesn't mean that it's wrong. I think that's where you come back to the style points. And, is your style better than others? Should it be a chart? Should it be narrative? Should it be 15 pages? Should it be 5? I think it's all over the place. But I think the key issue here is making sure that if you think you got the technical points and you're pretty sure it's commonsensical and you can read it and most people would understand it, move along. Don't worry about the style points as much. I would focus more on the technical and not second guess every time I see somebody else's, is mine good enough? Or you could be the other way and say, I'm better than everybody, they all messed it up. Whatever you like. But the point is that there's a lot of different ones out there, and I think over time we'll start to settle down to see what the standard, if you will be. But I don't think people are getting it wrong. I think they're getting it different. That's my observation.
Plain, straightforward language. When you have your disclosures under the wording of the proposed reg, the format has to draw the consumer's attention. It doesn't say flashing lights and warning bells. But we don't know how you draw the consumer's attention to disclosures that everyone's going to click through anyways. If you do business in a foreign language, you must provide your disclosures in a foreign language. The problem arises when you declare we only make our loans in English and you employ bilingual loan officers and loan servicers. Please remember, you're going to fall into that trap. And you're not limited to the California Translation Act languages. While you have to offer certain documents in many foreign languages under the Civil Code, if you do business in a different language under this set of regulations, it's likely you'll need disclosures in those languages. And you have to be aware that you have to be able to handle people with disabilities. So let's go to implementation issues, the next slide, and pull the next slide and the previous two slides together and talk about issues that have arisen and offer possible solutions or ideas, but not the only solutions and ideas. Notices, delivery, how and when. Okay, before you can collect any data, you have to provide all of these disclosures to your potential customers and consumers. If they are applying online, then you put the disclosures online, and based on how you do your business, either you say, to see our disclosures, go here, and then make sure you include a checkbox so they acknowledge they had that opportunity, or you put your disclosures in the beginning thing, and you either put them all in, scroll down when you're ready and check the box, or you have them check the box at every required disclosure. Yes, I receive the right to opt out. Yes, I receive financial incentive. Yes, I receive right to delete. Depending on how compliant you want to be, will be how you do that. Our recommendation is initially have at least one checkbox so that you can say, hey, they acknowledge receipt. I'd really recommend more for the key ones that the Attorney General has pulled out, but that will be your drafting and compliance and tolerance for risk in that regard. If they are filling out an application not online, but in their own time, when you give them the application, also provide the disclosures. And similarly, if they're doing an application orally or over the telephone, this is the hardest one. You are required before you collect any data. Hi, my name is Sandy. What's yours? You've now collected data. How do you provide the disclosures? You're going to want to develop a script, even a short script, that under California law, I have to provide you these disclosures. These disclosures are available online. Do you want to read them now, take a moment and look at them, or do you want to go over them with me now? And have your loan originators at least have a script that you can tell the world they follow and have a checkbox with that. We understand the tension between the requirements of the Act and the requirements of wanting to make a loan where the Act gets in the way. So your balance point is you have to provide at least some pre-disclosure to let consumers know they have certain rights, including referring them to your online disclosures or saying we'll put them in the mail when we send you our LE or our initial acknowledgement, but you must provide something before you collect data.
Sandy, if I could real quick ask you. Yeah, so, and if I can ask you, so what I get feedback from as well is, we don't collect information just on the front end. So it's not just the loan officer, but of course, processors certainly in a retail environment is going to contact the borrower and collect additional information. What do you recommend? What are your thoughts on a processor?
So the Act doesn't say every single time you have an interaction with your consumer. The Act says before you collect data, if you're involved in a single transaction, we would argue that the transaction may take days, weeks, or months to conclude, and therefore providing the information at the start of that transaction should be sufficient. If you're doing a refi or a workout, I would suggest it's not the same transaction. Yes, even a workout is not the same transaction. It's a borrower who's now distressed. We would recommend redisclosing. I do not recommend disclosing every single time you speak with your customers.
Very good. And I think it wouldn't hurt, this is my thought as well, and this is some of the feedback I got from the industry as well, is in the processor case, maybe at least in the first initial phone call, let them remind them of their rights of privacy, just to make sure that there's no splitting of hairs by somebody later, and we'll see the enforcement issues later, that was additional collection of data. So at least maybe one time that would be helpful. That would be a better practice and not best practice, I suppose.
Your processors have checklists, so put at the top of the checklist, remind of privacy rights. Implementation issues on notices. So let's go with verifiable consumer requests. Here's where your GLBA exemption applies. There are various kinds of consumer requests that can happen, and there are two issues with consumer requests. One is making sure that the requester is actually your consumer or their authorized agent, and two, how do you comply with it? So typically, you want to say, sorry, it's all GLBA data, I'm not giving you anything. That's a bad move. We think if you're going to comply, that you should make a genuine effort to provide the consumer with information. In the mortgage context, once the loan is up and running, I would recommend providing a copy of the note, the deed of trust, a payment history, and a copy of a reinstatement or payoff demand if the loan is in default. Those 5 documents contain most of the consumer's personal information that has been provided to you in the past year. If you're on the origination side, then I would provide to the consumer not a copy of their 1003, but I would provide to the consumer a copy of, again, if the loan closed, the note and deed of trust. I would provide a copy of the LE and the CD, and I would provide to them copies of any other disclosures you already provided together with your privacy disclosures. If the consumer pushes back and wants to know all the information you provided, that you have, including information they provided to you, I'm going to refer you to the proposed regulations and remind you that a business shall not at any time disclose a consumer's social security number, driver's license or other government-issued identification number, financial account number, health insurance or medical information number, account password, or security questions. In addition, the previous paragraph, C3, gives you protections against providing the consumer with specific pieces of personal information if the disclosure creates a substantial, articulable, and unreasonable risk to the security of that personal information. So if a borrower gives you a W-2 and then later says, hey, give me all the information you have on me, you can list your W-2. We don't want to provide it to you for security reasons, but if you insist on getting it, we're going to come to the second part of how to handle. This is where we are on compliance. If the consumer has an account with you, presumably there's an ongoing relationship in ways other than just telephone, use the channel that the consumer communicates with you. If they have online access, then set up a box for them with password protected double password cell phone verification to get their highly sensitive information. This comes back to now the first issue with verifiable consumer request, verification. If the consumer wants basic information, what type do you collect? Just tell them what type of information you collect. If they ask, what type of information do you collect about me? You'll have a very higher standard of who are you? How do we know? Let's have online verification if possible. If they come back and say, give it to me, that's going to be your highest level of verification, and that will be the method by which you provide the information. So this is a fraught area. So far, we understand that consumers have been asking questions under the Act, but not in huge numbers. Remember, the Act, which has its purpose of controlling who owns and protects the data, is really designed for the FANGs. It's not designed for financial services. The Facebooks, the Alphabets, the Netflixes, and the Googles of the world, not Joe's Mortgage. Ray, any comments on verifiable consumer request?
Yes, I think maybe you can help out here on expanding. So I understand where you're going and limiting the data where we can, and that's right. Reminder that the proposed rules are just that, they're proposed. They are not actual enforceable piece of legislation regulation currently, but it helps. It gives us an idea of where the thinking is for the Attorney General, and I think a lot of us, which is we don't. It seems counterintuitive for protect your information, I'm going to send you your Social Security number. It doesn't make sense to me, so I agree with that. in the context, Sandy. So in the context, though, if I think with the ambiguity of the law and the lack of regulation, each company might be a little bit different in what they're going to provide, the level of information, more or less, et cetera. But if they provided more, short of maybe the Social Security number, and even that, I guess theoretically, right now, currently we could do. I wouldn't advise it. But if it were the appraised value, the LTV, or anything like that, even if we say, look, we don't have to provide it, could they provide it? It's just easier sometimes to not. It's like no sweat off their back to generate a report. They can deliver it. Couldn't they just deliver that?
The answer is yes, absolutely yes. The only concern that I raise, the big concern I raise is security. You want to make sure that you deliver the consumer's information to the consumer in a secure way. Because the business's only liability under the Act that's undisputed is for data breaches. A data breach is not defined as having 1 million consumers or more. A data breach could be one individual consumer's records. And this area of the law, while consistent with the law, is the area fraught with tremendous exposure and ruin for people, and that would be the liability to the company. Right. I didn't talk about the request to delete yet for verifiable requests because I want to do that on the next slide, but that's where we are for verifiable consumer requests. I want to turn to website. There are requirements on the website for the California Consumer Privacy Act. You're supposed to have a button on the website face page saying delete my information, request to delete. The law provides you can set up a California specific homepage. We recommend that. So somewhere on your homepage, instead of saying request to delete, thereby attracting the attention of 49 other states' consumers, you want to say, we love our California consumers. If you're a California consumer, click here, and then put all the California information. Staffing. If you haven't already, or you haven't want to make changes, set up a special unit. This does not mean go out and hire people. This means look at your CSRs, your customer service representatives, the people who handle your hottest customer questions or regulatory inquiries, and train 1, 2, 3, 10 of these people on the CCPA until we have a feel for what kind of questions we're getting. So when either telephone questions, written questions, email questions, or requests come in, your special people will be able to handle them and know how to implement your policies. On the compliance side, you've heard me say this before, perfect is the enemy of the good. You need to set up good compliance that protects you and protects your consumers. And once you set it up, be consistent in how you carry it out. You have waterfalls on how you make loans. You have waterfalls on how you modify loans. We need to set up a waterfall on complying with privacy based on the level of the request and the information to be provided. As I move off implementation issues, Ray, any other comments at this point?
No, that's good. Thank you. Next slide.
Data issues. So let's go to the next slide. Okay. Do you need the data? Yep. Do you need the data? The answer is yes. You must have the data to do your business, to service the loan, to originate the loan. You absolutely have to have the data. Do you really need the data? No, of course not. Once you get past loan servicing, you don't need the data. It's really cool to hold the data. Take a look and see what kind of data you have. You may have data on existing customers. Okay, keep it. But you may be holding data that consists of leads you generated 4 years ago that didn't go anywhere. Those people have moved. You will get new leads. Purge that data. Go through and dump stuff you don't need. Please, please get rid of it. This is not just litigation hold and cool stuff. This is if someone comes around to enforce it, you don't want to have it. Data retention. Rather than relying on GLBA, remember you're a financial services company. There are prudential regulatory rules that say you must maintain the data during your tenure with the loan and for N years after that. In addition, you have to realize you're liable to be the object of litigation and want to retain the data at least for the statutes of limitation purposes. In California, for example, Negligence is 2 years. Fraud is 3 years. From discovery, breach of contract is 4 years. Firea is 7 years. No term in the note with a deed of trust is 60 years. Okay, don't rely on that one. So you want to retain your data through the transfer or payoff of the loan, plus at least 4 or 5 years for regulatory and legal purposes. If you want to retain it longer, please de-identify it. Take out the borrower's name and identifying information, but you can hold it for that long for your protection and use. I want to highlight repurchase demands on the slide because not every investor has limited repurchase rights. Yes, there could be 6-month EPDs. Yes, there could be the loan goes down. There could be defaults. There could be whatever. But it's unlikely an investor after a performing loan lasts 7 years will ask you to repurchase. When you look at your investor contracts, if there's a period of time that cuts off, you're good and can start deleting data at that point. I know Fannie goes forever. So when you have those issues, you have those issues. But retention is good, and it's the legal thing you're retaining, not the GLBA exemption. It's the legal reason, and you provide the customer data in response to their requests, because it's a good customer service thing, not the GLBA exemption. So while the GLBA exemption should be relied on and is there, I don't like it, and you've got so many other things, not a worry. Security and data breach. You are liable for a breach for failure to implement and maintain reasonable security procedures and practices. Okay, we're going to test that. Remember that if you think you have reasonable security procedures and practices and there's a breach, aren't your practices not reasonable? In essence, I have no idea what this section means in terms of protecting us. What it really means is if there's a data breach, you're in trouble. So yes, you have to maintain GLBA security, but I think it's a higher level now in light of the goals of the statute. And obviously you're doing regular testing and protections. Cloud storage, while secure, may not be as secure as you would like, but I point out this is an issue for us and we need to keep working on it. And it's an enormous issue which will only get bigger. Enforcement, slide 11.
Hold on, Sandy, if I can,
Yes.
I can jump in real quick. I think it's important to talk about the retention requirements, and Sandy and I had talked about this, and others. No, it's okay. Don't worry about it. That's the point of how we start thinking about data, and I think it starts with us, and I think it's going to take time for the industry to catch on. But as you mentioned earlier, it's no longer the world of GLBA, which is as long as we secure it, we're okay. It's now we don't own the data, so we're subject now. We are slaves to the consumers as to what data we have and what we can do with it. So it's smarter to start deleting things and really monitoring the retention requirements and purging things when you can purge them. And maybe even asking the question of why are we collecting the data? Should we even be collecting this data? And ultimately, and this is the scary one, I think, to anyone who's in the operations, what about those files that are in the processor's drawer, underwriter's drawers? What about the email with the W-2 that was sent to the loan officer, which went to their mobile phone? We're starting to we have to think a little more broader as to where the data is. I'm not saying we have to do everything this quarter and be done with it and push, but I think there's an evolution and a different perspective, a different philosophy of how we manage data, and we need to start thinking about it that way because it's not getting better. You see the laws coming up and other states doing the same thing. It's not going to be loose, it's going to be tighter, and so we start thinking more closely about how to really shepherd that, including with our sales and operations departments. And I'm off my soapbox.
I'm going to come back to that. Nope, I'm going to come back to that. Enforcement. Okay, yes, the Attorney General has enforcement powers. You know that. I can't help you. Attorney General is going to ask you questions. He's the Attorney General. You got to deal with it. Private right of action. The only private right of action expressly set forth in the CCPA is for a data breach. And based on the funny language copied from the ballot proposition, the CCPA says, nothing in this title shall be interpreted to serve as the basis, not for a claim, but the basis for a private right of action under any other law. I think that was meant to be a predicate act under Business and Professions Code section 17200, which requires, in order for there to be unfair competition liability, that a plaintiff plead and prove the defendant's conduct violated some independent substantive statute, regulation, or case law, that is, a violation of the CCPA could be a basis for a claim under 17200. The courts will have to sort out this inartful definition. I am not going to tell you how it's going to come out. I'm only going to tell you that there are very, very smart plaintiff class action attorneys out there, and they're going to raise this argument. And even if it loses, it's going to cost us hundreds of thousands of dollars to solve the problem. So compliance is key, and carrying it out with the checklist and implementation is key, but we don't have a safe pass on the private right of action. I don't think this is going to arise in the case of performing loans. So for 97, 6, 5, 8, 9% of our loans, not at issue. But where a loan goes down, we currently see, before lawsuits are filed or early in the lawsuits, we're seeing the QWR equivalent of, I want to have copies of my records. This is really big in Ohio, by the way. I want to have copies of my records so I can help write a better complaint. Okay. I think we're going to see this in the CCPA area, where consumers and their attorneys are now going to say, give me all of my data for the last year, and I mean all of my data, and I'm going to scrub it through the data analyzing experts out there who will then increase the number of causes of action in the complaint. And by the way, if you don't give me the data or you give me any hard time, you're going to see a 17200 CCPA claim in the lawsuit that we defense counsel will have to deal with. So that's what I think is going to happen on the enforcement side and how it's going to happen, which is why we recommend using your better CSRs to respond to the CCPA questions, because if it's a defaulted loan, it's a warning you're about to get sued. That gives you a chance to mod or solve the problem before you get the lawsuit. Let's take a look at next steps in our remaining time. What to do now? Okay, implement your data plan. You've already got your plan, it's already in place. If you're a little behind and you've been thinking about it, you have to implement the plan. The act was effective January 1st. The AG is coming July 1st. Review your data. This is what Ray alluded to and said. Your data is supposedly on your servers, in your servicing records, in your origination records, in your system of record. No, it's not. Every single one of your employees who has customer interface keeps a personal file at their desk, on their phone, at their home, and it's all your data. And you have to find a way of getting it, controlling it, and deleting it. And I understand that when Charlton Heston was head of the National Cell Phone Association, he said, you will get my cell phone only out of my cold, dead hand. Yeah, I've spoken with LOs. Ain't happening.
Yes, you have.
But you got to find a way to get it. If you guys aren't old enough to know that Charlton Heston and anyone is in this role, I apologize. Okay, take a look at your disclosures and policies. I have collected privacy policies. If you want, contact me in February and I'll send you 10, 20, or 30, or 100. It's fun reading. Review these other companies' policies to see what they've done. You don't need to change yours, but if it helps you strengthen yours, giving you more protection, that's a good thing. Obviously, you're testing your procedures, training and monitoring your personnel, and you're watching out for final regulations. Okay, good. What's coming next? Next page. The feds are going to do something. No one knows what they're going to do. My prediction is it's not going to be preemptive. You will still be handling states. Yes, there's California regulations. Yes, there's California amendments. We put out a monthly update on tracking the bills. I won't start it until February 21. If you want that, and Pat is not doing it with CMBA, we're happy to do it. I do like Pat's updates, and I steal his information. Other states are working in this area, and they are being introduced now. Yes, they are copying California, but some other states surprisingly resent California and want to do their own, and they can do it better. Translate better as worse for industry. And there's a ballot proposition coming in November. I think that the ballot proposition is now outdated in light of changes that have been made in the way the process works. But stay tuned. So those things are happening. Yeah, there are things we don't know. There are lots of things we don't know. There's a few things we do know. See you next quarter when we have more information. If you want to reach out to either of us, we're here. Thank you for listening.
Well, thank you, Sandy and Raymond. Wonderful presentation. Lots of good information. We do have, we're a little over, however, very important topic, so happy to take some questions for a few minutes. Gentlemen, I do have a couple of questions that have already been submitted, so if I may start to read off some of those, maybe we can answer those quickly and get through to some of them. If you do have a question, with time permitting, we will try to get to all of them. You can use the questions dialog box on the right-hand side of your screen to submit those questions. So first question, as it relates to the use of third-party vendors, technology platforms, and use of appraisal management companies, the consumer may be directed to a platform to provide personal information, credit card payment, and/or in the case of loss mitigation, financials. Who then is responsible for the online disclosure and at what juncture?
Sandy?
Thanks, Ray.
Bob?
Part of that...
Yeah, of course.
You're very kind. Part of that comes to is who is the third party who's collecting it. So if it's a separate service provider, they would have to provide the various disclosures currently, but they may not have to if they're smaller and don't qualify as a business. Since you are sharing your data with them, if they are a service provider, they are then responsible to you, and the issue arises, no new disclosures need to be provided if they're not a business, but if you are asked to delete the data, you have to tell that service provider to delete the data. So it's kind of a square answer to a round question. I hope that helped, and I'm happy to talk further with the person.
And yes, and I would expect simply that I would simply add that don't expect that you're not responsible.
There was a request to have your contact information back up on the screen, so that's why we're back to that slide. If you want to be in touch with any of our speakers, there is their information. We'll see how many of these we can get through. Is there an opinion on how active the AG will be in this area if no additional staff is being added to that office?
Nobody knows.
How active they will be?
You recall?
Okay, thank you.
Active. You recall that a year ago, the AG wanted nothing to do with this, submitted proposals to the legislature that they shouldn't be the ones drafting the regs, it should be a different department, that they shouldn't be the enforcing agency, that there shouldn't be questions. But the AG is the entity. The AG is setting up a whole department to deal with this, and the ballot proposition is creating a whole new sub-agency. We are expecting the Democratic California Attorney General to take his responsibilities under the CCPA seriously, and they will be enforcing it to protect Californians' rights. To answer the actual question directly, nobody knows how active, but they're not going to be silent, and they are going to be in the space.
Yep. Agreed. Two more questions real quick. Will this disclosure become another document required for clear to close?
Ray, I need your help on this one.
Then I got nothing.
Which document are we referring to?
I think the privacy notice or the initial notice, either one, right? The question becomes, I'm assuming it's the documentation regarding the either the privacy notice or the initial notice, which we kind of combine if it's online, and maybe more importantly, do we have to evidence that it was provided to the consumer? The answer is I do, and for clear to close, the answer is I do not know.
Okay, so that translates into yes.
Right.
You have to give the notice.
Last question that I have.
Sorry.
Last question that I have right now is how do we handle wholesale brokers who are small entities and not covered? Are covered lenders requiring their wholesale brokers to provide the disclosure?
I don't know what everybody is doing, obviously, right? And I can understand that a broker doesn't meet the threshold. So in a wholesale environment, what I have heard is I don't know, you can compel them. I mean, of course you can compel them to do it, but some of them are providing, the wholesale lender is providing a written notice with the initial disclosure, so at least they cover themselves upon receipt of the file, even though that begs the question whether they got the notice, they provided the notice before collecting the information, but that's what I've heard that they are doing from a wholesale perspective. I haven't heard a lot of them causing all brokers to do it. I think that might be a push simply because brokers aren't required to do it. But again, there's ambiguity as to what do we do in a wholesale situation, because you cannot provide a notice before you collect the information. It doesn't work that way, and it's not designed for wholesale. So proverbial, like anything else, my recommendation is do the best you can and take it from there, as long as you can articulate, as we said before, you did enough compliance, you can articulate why you chose a particular course of action, defend it well, and take it for it might be different than someone next door. It doesn't mean they got it right either. We just don't know. It's pretty much silent. Sandy, did you want to say something? I'm sorry.
Yeah, it could be that it's the same thing you said. The wholesaler who's not a business, I'm using the term of art, under the Act doesn't need to provide these disclosures. But once information is transferred to you and you're collecting it, and you're going to have a relationship or potential relationship, and you send out some type of welcome letter, hi, we received your loan package, we're evaluating it, include the privacy disclosure at that time.
Correct.
If the loan is originated by a smaller lender and then assigned to your shop, either through sale or servicing transfer, when you either send the TILA I own the loan notice or you send the RESPA welcome letter, include your privacy policies. Go ahead.
Very last question. Are branches required to post a CCPA policy in each branch next to their standard public disclosures, like fair lending, ECOA, HMDA, licenses? Are the branches required to do that?
I have not heard of that, Ray. And the say that specifically.
No, I would say this is primarily, again, because there's a lot of gaps, but this is primarily website, and I think everyone on the call has a website. It's more web-based. So no, you do not have to do that. There is some things there is an expectation if you do a lot of face-to-face, like a branch or something, there is maybe an expectation you do that. You can do that, but I think it's not crystal clear that you have to do that. It doesn't hurt to do that, but I don't think you have to do that.
Okay. All right. Well, gentlemen, thank you so much. Again, great content today. We have recorded today's webinar. It will be made available on our website, probably, I'd say by tomorrow, possibly Monday, but you look for it then. Also mark your calendar for our next mortgage quality and compliance webinar, which will be on Thursday, February 27th at 11. And we'll be sending out marketing material as to the topic that we'll be covering, but I'll certainly invite you to join us then. Thanks again for your participation today. Have a great rest of your week.
Thank you.